President Saunders, Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, hearing of appeal in GYCV number 3 of 2023 between Nadira Nunez, Victor Nunez, Mahindra Naut Basdeo, Ramesh Basdeo, Sandra Drupati Bisundari, Indra Rohini Hamarik, Swadesh Basdeo, and the estate of Ramsaywar Basdeo and Robina Basdeo. The members of this morning's panel are Mr. Justice Saunders, President and the presiding judge.
Good morning, Council.
Madam Justice Rajnath.
Good morning, everyone.
Mr. Justice Barrow. Mr. Justice Burgess.
Good morning, Council.
And Mr. Justice Jamada.
Good morning, everyone.
May we have the appearances, please?
Good morning, Your Honours. May it please Your Lordships, I, Manoj Narayan, appear for the appellants. Ms. Chandini Dayal appears with me. The appellants are present, Your Honours.
Yes, good morning again.
Good morning, sir.
Good morning, Your Honours. Nigel Hughes. I appear along with Ms. Narissa Leander and Ms. Nadia Gomes for the respondent, Robina Basdeo, who is also present with me.
Yes, good morning again, Mr. Hughes. Before we get on the way, Mr. Hughes, there's something that is troubling me. There have been a number of other proceedings among these parties. Is that correct?
That is correct, Your Honor.
Okay. On the 15th of May in 2012, Chief Justice Chang made an order by consent that Ramesh Basdeo and your client, Robina Basdeo, would apply jointly for a grant of letters of administration for the estate of the deceased.
That is correct, Your Honor.
Is that order still extant? Has it been set aside? Are there any proceedings for it to be set aside?
No, Your Honor, there were no proceedings for that to be set aside.
Okay. Did the letters of administration that were contemplated when the order was made, was there any indication as to what was the property that would comprise that estate?
Your Honor, I'm afraid nothing was done in relation to the administration of the estate after the consent order was made before the Chief Justice. So there's been no listing of the assets or liabilities, neither has there been any action taken towards advancing or progressing that estate.
I see. Okay. Mr. Narayan,
Yes, Your Honor.
Yes, you have appealed the Court of Appeals decision. What is the order, if assuming that you are successful, and just for the sake of argument, what is the order you wanted this court to make?
Your Honours, before I answer that question, if I may briefly respond to the last question asked by this Honourable Court to Mr. Hughes. Your Honour, I don't quite agree with Mr. Hughes, respectfully. At the time Ramesh Basdeo made an application for letters of administration, the assets of the estate were duly declared to the Guyana Revenue. Prior to that, the necessary estate duty were paid and the certificate issued, and those documents did form part of his application. Your Honor, the respondent was a party to those proceedings, and so there was a list of assets declared for the estate, and estate duty paid, and those were part of the proceedings. So I don't quite agree.
Just a second. And that application was made pursuant to the order that was made by the Chief Justice on the 15th of May 2012?
Your Honor, the declaration was done prior. The declaration to the Guyana Revenue Authority was done prior to the application by Ramesh Basdeo for letters of administration. So that application contained a list of assets and liabilities that were all listed in it.
Yes, but I'm concerned with the order that was made by Chief Justice Chang and the import of that order, the consequence of that order, and what was contemplated by that order. And I don't have a very clear answer from you on those questions. There is an order that I'm seeing, or I'm hearing of, that on the 15th of May 2012, Chief Justice Chang ordered by consent that Ramesh Basdeo and Robina Basdeo shall apply jointly for a grant of letters of administration for the estate of their father, Mr. Basdeo.
That is correct.
Now, you're telling me
President,
about an
President,
application. Yes.
If I may ask,
this is bad.
Was that not preceded by an application by Ramesh alone counsel?
If what was preceded, kindly, Your Honor?
The granting of the administration by consent to the two persons.
Your Honor, if I may, the letters of administration was not granted. The order of the Chief Justice was that by consent, both parties shall proceed to apply for the grant of letters of administration. So the order did not grant to them a letters of administration. They were to take the necessary steps to apply to the probate registry of the High Court to apply for a grant of letters of administration.
Okay, let's try a different way. When that order was made, as I understand it, you're saying that Ramesh had already embarked on proceedings or applied for a grant of letters of administration. Is that correct?
He had commenced, the process was commenced prior to the application before the Chief Justice, Your Honor, but it was never completed.
Okay. When the Chief Justice made this order, was it made in contemplation of that prior application? Is it that the Chief Justice was saying, look, I am seeing here an application that was made by Ramesh Basdeo. I'm now ordering, by consent, there was an agreement apparently, that that application is to go forward with Ramesh Basdeo and Robina Basdeo jointly applying. Is that what occurred?
That is correct, Your Honor. Your Honor, forgive me if I may not seem as though I am fully aware of what transpired, but I wasn't counsel on record for the respondents at any time prior to that. But that certainly was the intention of the Chief Justice. And it is in the record of appeal as well, Your Honor, that the then counsel for the appellants wrote to then counsel for the respondents requesting that the necessary affidavit or the oath to lead the grant be submitted so the parties can act in compliance with the Chief Justice's order. And instead of complying, the respondent, Robina Basdeo, responded by way of a letter from counsel saying, and essentially, she cannot do so because she's claiming an entitlement to all of the properties which form part of the estate. Your Honor, that is on the record of appeal, I believe. I can tell you now. It's at pages 323 to 324 at paragraphs 95 to 97 of an affidavit sworn to by Robina Basdeo. And those paragraphs are repeated again at pages 449 to 450 of the record of appeal before this court, Your Honor.
Counsel, nothing happened after that with respect to the consent order or of the actions or conduct of the respondent. Am I right? Or did anything happen after?
Your
Any
Honor,
steps taken?
I came into the matter shortly thereafter. Two applications were made by my chambers after the grant of that consent order by the Chief Justice. The first was an application by Ramesh Basdeo to vary that consent order of the Chief Justice and to allow Ramesh Basdeo to proceed by himself to apply for the letters of administration for the estate. That application was dismissed because, of course, it was a consent order, and the Chief Justice at that time found that it was not procedurally correct to file an application to vary a consent order. So that was dismissed. The second application that was made, Your Honors, is a notice of motion which was filed against Robina Basdeo for contempt for failure to comply with the orders of the Chief Justice. That notice of motion, I refer to it in the list of previous cases submitted to this Honourable Court. And that motion is numbered. That motion never proceeded, Your Honor, because the application, well, the current proceedings, the proceedings from which this appeal emanates, commenced hearing, and so that motion was never fixed for hearing or heard.
Okay, so let's get back to one of the initial questions I asked you.
Yes, Your Honor, I can
You
go
are
back
the
to answer.
appellant. You are the appellant
Yes.
in these proceedings. What is the order that you are seeking?
Well, Your Honor, first of all, I intended to make, upon being given the floor, I intended to make, with the leave of the court, an application to limit the grounds of my appeal and the scope of my appeal. And if the court will permit me to do so now, Your Honor, as I can state the basis for this application.
Counsel,
Yes,
help
Your
me
Honor.
here. I am really interested in finding out your answer to the question just asked by the President. What order do you seek from this court in these proceedings, given all that is pending, all that is outstanding, etc.? From
Well,
this court in these proceedings, what order do you seek?
Well, okay, I'll answer that question, Your Honor. Your Honors, I am seeking an order. The trial judge made an order or a finding that the respondent, Robina Basdeo, fully recouped her investment from the period from 2006 to the date of decision in 2017 out of the income and profits from the business. The Court of Appeal set aside that order, Your Honor. So that is one of the orders I am asking this Honourable Court, or the finding, that's one of the findings I'm asking this Honourable Court to restore.
So you're asking the court to find that the respondent has already recouped whatever funds she had put in to your client's father's property business.
That is correct, Your Honor. Your Honor, I am no...
But I'm trying to see how material is that issue. Are you challenging the decision that the letters of administration should proceed as made by the Chancellor?
No, Your Honor. That's one of the items I was planning to deal with very early in my submissions, that I am not challenging that finding, nor am I challenging the finding of the Court of Appeal that the trial judge was correct in setting aside the various documents previously relied upon by the respondent.
Well, if the letters of administration are proceeded with, I assume in keeping with Chief Justice Chang's order in 2012, you're saying that there would still be hanging over your head the issue as to whether the respondent had recouped her monies.
That is correct, Your Honor.
If that is not set aside.
And counsel, that is the only issue you have to raise before us, you say?
No, Your Honors. The other issue, Your Honors, is whether sufficient consequential orders were granted by the Court of Appeal.
Like what?
For example, Your Honors, the respondent Robina Basdeo continues to solely operate the sawmill from the date of the High Court's decision in 2017 to present. So should there be orders for her to account with her dealings, given that both the findings of the High Court and the Court of Appeal are that the properties are to be divided in accordance with the rules of intestacy, and one of those beneficiaries has been in sole possession and occupation, and solely reaping and retaining all incomes, profits, and benefits therefrom. In the High Court proceedings, the appellants did seek an order for the respondent to account for her dealings with the assets of the estate.
And what
So
did the
no-
judge say? What did the High Court judge say on that issue?
Your Honor, the High Court judge only found that the respondent, Robina Basdeo, had recouped her monies, and she proceeded to order that art sampling, which is registered in the name of Robina Basdeo and her husband, do immediately remove from the property. She did not order any, she did not make any orders for an account to be rendered. But of course, that would only apply to the time of her decision. So even if no account should be ordered from the time from 2006 until the High Court decision, certainly from 2017 when a decision was given to now, order should have been made for an account of the income and profits retained from the assets of the estate.
But Council, as I understand it, there are on foot, or there were proceedings in relation to the question as to the recoupment, the repayment of the loan, etc., right? There are separate proceedings. There are separate proceedings relating to that. You just said the High Court judge found that she had recouped, correct?
In these proceedings, Your Honor. In these proceedings.
No. Sorry. Were there in other proceedings such a finding?
No, Your Honor. None of the other proceedings dealt with this issue.
Okay. So the question is whether or not the estate is able to recover from her the monies that she earned. The question is what is due from Robina to the estate. Is that not correct?
That is
or
correct.
the other way around?
Or the other way around. So those are all issues which hang in abeyance.
Yeah, but those are not matters that we can deal with, are they?
Well, Your Honors, I do believe this court can deal with the issue of an order for her to account for her dealings.
But Council, how could we? For instance, there is no administrator of this estate. So it seems to me that the determination in this case was a determination in a case brought by Robina, essentially to have the court endorse her ownership of the properties. The court has refused that order. She is found not to be entitled to the properties. That is the end, as far as I am aware, of the case which Robina brought. Was there a cross appeal for an account to be taken, etc.? Could there have been a cross appeal by these present defendants, now appellants? Yeah. Yes. Could there have been a cross appeal by them?
Certainly, Your Honor, they could have filed a cross appeal to the Court of Appeal.
No, hold on. They not being representatives of the estate?
I'm agreeing with Your Honor. They could have filed a cross appeal.
But how could they? If they would be seeking, the cross appeal would be for Robina to account to the estate.
Yes, Your Honor.
But they do not represent the estate.
But as beneficiaries, Your Honor, they have a sufficient
with the greatest respect, beneficiaries cannot sue on behalf of the estate. They don't have the standing. They have the interest, but they don't have the standing. Therefore, they or one of them would need to apply for letters of administration and become, in effect, the deceased person's representative. No?
Or alternatively, after somebody, because one of your clients, I believe, has applied, well, there was this consent order, but no grant has been made. After a grant has been made, then they would have standing to ensure that the administrator or administrators execute the trust that the letters of administration grant would have endowed them with. In other words,
added to that, Council, there is the fact that there is something, as I understand it, I'm not sure what the law of Guyana is on this, a thing called administration pendente lite. somebody who is not even the administrator can apply to the court for an order that you appoint me as administrator for the purpose of particular proceedings.
That's correct, Your Honor. We do have provisions that allow for such an
So then how is it you are saying that the siblings, the beneficiaries, are entitled to apply when you know that the proper person to apply is the administrator of the estate? You see
on
why?
On the issue of rendering an account, Your Honor.
What's that?
On the issue of rendering an account from Robina Basdeo.
But how could they? Because she would have to account to the estate. So it is only the administrator, the representative of the estate, who can require that.
So that after your client says, have obtained, assuming your client and Robina, or if you get that order somehow varied to you alone,
or a separate order pendente lite, President.
Or a separate order pendente lite. After that order has been obtained, then that is an issue to be dealt with.
Perhaps, Your Honor. Your Honors, I fully appreciate the concerns that are being raised by this honorable court this morning, and I will be frank with the court that I had these discussions with my clients. They're all here. They can confirm. I had these discussions with my clients on whether this appeal should be withdrawn or not, given what the findings of the Court of Appeal are as contained in the decision handed down, the written decision last Friday. Your Honors, they were adamant that they wanted to proceed. I asked them to give me those instructions.
Proceed to what end? We're not going to waste our time in futile arguments, discussions, hearings. So the purpose of having this discussion before the appeal gets underway is to find out whether we'll be wasting our time. Yeah. And so far, we haven't heard anything that suggests to the contrary.
Your Honors, that was what I discussed, and the only issue they raised, and I did not want to make any application in defiance of their instructions, Your Honor, because that will put me in serious ethical problems. But they had concerns about the fact that Robina may still be able to claim that the estate is still indebted to her for the investments, since the Court of Appeal essentially found that they did make a finding on whether those investments were recouped by her or
But
not.
Mr. Narayan, won't that be sorted out on an accounting process? When accounts are done, you know what her investment was, don't you?
Yes, Your Honor.
Right. So when you do an account, a proper account will reveal whether the business was profitable or not. Yeah, a proper accounting will reveal all of the details of what was invested, what was paid out, etc., etc., etc. And that's the only way, unless somebody sees accounts. How do you know whether something has been recouped or not? You have to have an accounting process, don't you?
Of course, Your Honor. And there was, in my humble opinion, Your Honors, sufficient financial information before the trial judge upon which the trial judge based that findings. Well, that particular finding.
And what would that be in your view, in summary, Mr. Narayan?
Your Honors, before handing down her written decision, the trial judge had ordered that financial statements be prepared and submitted, which they were done. They were submitted by Robina Basdeo. Those statements show the sales and the expenses of the business. In addition to that, Your Honors, there were a sales book that was produced by Robina Basdeo for a period of time, which showed the daily sales. There were several receipts for items which were purchased by Robina Basdeo, which were tendered into evidence. All of these items essentially showed how much money the business was making. And, Your Honor, intelligent, logical deductions could have been based or could have been made from those figures, Your Honors.
But the first document you speak about, the statement of accounts and so on, was that a properly filed document? Was that a document which stood the scrutiny of cross-examination or or anything like that? How do we get to the point to say that that was a valid document before court?
It was, Your Honor, it was not subject to cross-examination, but it was admitted by the consent of the parties at the time before the trial judge rendered a written decision. It was the court's order that such a document, with the consent of the parties, be prepared for the benefit of the court.
Counsel, does that document show
go ahead,
any particular date, does it show who owes what to whom?
No, Your Honor, it was simply a document of income and expenses for the business for over a period of time.
Then, Counsel, is it not the case that what is needed is a complete accounting which shows who owes what to whom, who received what, etc.? Yeah?
I cannot agree with you more, sir. That is precisely what is needed.
Then it seems to me that being equipped with a determination that the properties belong to the estate, you go forward from there. And that it never belonged to Robina, you go forward from there. Not in these proceedings.
Counsel, I get the impression that what concerns your clients would be the issue that the Court of Appeal did not agree with the trial judge on the recoupment. So that they will always be faced with the fact that the respondent will say to them, but you owe me those monies. That's what the Court of Appeal has said. That is what I imagine is the issue.
That is precisely one of the issues, Your Honor.
But Counsel, let me interrupt you. You would allay their misgivings by saying the Court of Appeal made no finding as to who owes what to whom. The Court of Appeal simply set aside a finding that there had been a recoupment on the basis that there was no evidence to support it. That does not stop that evidence being presented in the proper process. The Court of Appeal did not say that there were settled accounts. The Court of Appeal did not say, sorry, am I still on? Yeah. The Court of Appeal did not say that this matter is, or say anything which made the matter res judicata.
That is correct, Your Honor. You know
where to go from here?
Your Honor, I discuss all of these issues with my clients. They are here. They can confirm it. They gave me express instructions: do not withdraw their appeal. Your Honor, I could not.
Well, Counsel, you now have the benefit of the discussion with the CCG, which tells you that what you raised with them as your concerns were well-founded concerns, and that they were well-informed and they were sound concerns, and that therefore they should now revisit your advice and act accordingly. Yeah?
Your Honor, I expressly told them I do not see what else what orders the CCJ can make given the findings of the Court of Appeal. I expressly told them that, and they simply did not give me their consent.
I commend you, Counsel. I commend you.
And I'm saying it in front of them, Your Honor, so they can confirm or dispute what I'm saying, Your Honor. So I had a 2-hour discussion at 12 o'clock in the evening, a couple nights ago, Your Honor.
There we go.
Are you all in the same location?
No, Your Honor. I am in Guyana, and most of the appellants currently live and reside overseas.
I see. Well, there is a way. I don't know how IT savvy everyone is, but if we stood this matter down for 15 minutes, there is a way in which you can converse with each other and then come back into the call. So would you like us to do that?
I can reach them on WhatsApp even without the use of that technology, Your Honor, and hopefully do a quick group call.
Yes.
And resume the hearing.
Okay, before we do that, Mr. Hughes, is there anything that you would like to say? You're on mute, Mr. Hughes.
I'm sorry, my profuse apologies. You mean in relation to the discussion that has been had so far?
Yes.
No, I have nothing to add, John. I think it essentially this is not for me to comment on because it essentially involves my learned friend and his client's position.
Yes. Okay, I tell you what we do. We'll stand on the matter for it's 10:30 now for 10 minutes, and we resume at 10:40. That's the time in
President, could
yes.
we make that 15 minutes? I'm
15
having
minutes.
an IT issue with my computer. Therefore, IT will see if they can intervene and have me join on my computer rather than on my handheld device.
Sure. Okay, so let's resume at 10:45. The court now would stand adjourned until 10:45 Trinidad time.
Thanks, President.
Most grateful, Your Honor.
Okay, I think we're all back.
Mr. Justice Barrow is not here, is it?
Yes. Let me show that this is fast. We wanted to clarify among ourselves. Now, just as a matter of clarification, letters of administration were applied for by Ramsaywar Basdeo. Those were granted?
No, Your Honor.
Okay. They're still on the foot, so to speak.
That is
The
correct, Your Honor.
application is still...
Mr. Hughes, can you confirm that? No letters were granted.
As presently advised, no letters were granted.
And then counsel for the appellants, why is it that in the title of the action, the 8th defendant is described as the estate represented by Ramesh, the administrator? That's an error on your part?
Well, that was just, yes, Your Honor. That is how the action was commenced, and it just kept going.
Yes, but it was commenced against him as administrator. So, oh, sorry, that's Robina's error.
Yes, Your Honor. It was commenced that way, and the parties kept it throughout that way throughout the proceedings without bothering.
So for all practical purposes, everybody has accepted that Ramesh is the administrator. Is that the case?
Well,
Mr.
Your Honor,
I'm not sure that I'd be comfortable with the description accepted.
But you have not objected to it?
Yes,
And
there's an
yet,
absence
you
of
have to
objection.
sue them as such.
Yes, indeed. All I'm saying is that accepted is a slightly stronger than how I would describe it, but I certainly am responsible for the filing of the proceedings, and yes, the error is mine. I accept that.
Okay.
Okay. Well, here one. We would turn that error into we will kind of realize the correctness of that error, if I'm making sense. We would want to stay this matter. Now, Mr. Basdeo, the father, he's been dead now for what, over 10, 15 years? And this estate is just meandering along. It is time that letters of administration be granted for this estate and for the estate to be properly administered. And so we'll stay the appeal, and we would order in the interim that Ramsaywar Basdeo proceed to with the application for letters of administration, and we will grant liberty to the parties to come back to this court in the event that there is any issue regarding this order that they wish to have settled or clarified. But Chief Justice Chapman made this order since in 2012. This is 2023, and it is clear that Robina, if she has claims against the estate, or is in dispute with the estate, she can't be on both sides of a dispute. And so,
Sorry,
we would
President, and equally, if the estate has a claim against her,
equally,
she can't be an administrator.
she
Mr.
can't
Hughes,
be
where's
on both sides.
Robina, by the way?
May I please, Your Honor, she's here.
Good, I'm glad to know that.
Yes. Can I just inquire, and this is purely because, as Your Honor has observed, it's been a long time, and I anticipate that our difficulties wouldn't necessarily be assuaged today. May I just inquire whether Your Honors are vacating the order of the Chief Justice, because the Chief Justice's order said it was going to be a joint application. And the second concern I have, based on my history dealing with the litigants, is that in relation to the assets of the estate, there's clearly going to be issues there because, of course, the Court of Appeal recognized that there wasn't sufficient financial information. And I don't know if Your Honors would be disposed to offer some guidelines, not for the purposes of counsel, but for the purposes of the party in relation to the accounting that has to be done. Because the history is, Your Honor, that as soon as you suspend this, there will be a resumption of hostilities, which neither myself or my learned friend, I believe, would necessarily be able to contain. And I know the court expects certain things to be done, but I just would want to invite, and please forgive my impertinence, the court to perhaps provide a few more detailed guidelines about what should happen here going forward before we report.
What kinds of guidelines are you suggesting? Like,
well, clearly, to determine the assets of the estate, the liabilities of the estate have to be determined. That is going to be an issue, simply because the liability is not just the loan that was repaid and the level of indebtedness, but it is the particulars of the loan. Is a forensic accountant going to come to say that this loan was stretched over 10 years, 12 years, 4 years? I can see us having difficulties in the details, primarily because it has been run. Then there's the issue of a separate entity, which the respondent, Art Sawmills, established, and that has its own assets. It's completely separate from Basdeo. And that's going to be another issue. The present
but Counsel, let me interrupt you.
Sure.
Aren't these questions which must be raised in the process of the administration of the estate?
No, I
in the
wasn't
process.
Saying, Your Honor, I wasn't for a second suggesting that they would not be raised then. I am just trying to avoid this being unnecessarily. You see, Your Honors have the benefit of authority. And yes, these issues would be resolved. The question is who resolves them and who is the mediating personality or institution that manages this in the interim. That is perhaps what I was inadequately trying to say. I know it's not the duty of the court.
Ever gone to mediation on those issues?
I don't think so. I'd be guided by my learned friend's younger memory, but I don't have a recollection of that happening.
I don't have a recollection of that since I joined the proceedings in 2012, Your Honor.
Well, that is one approach. Certainly, this court here and now can't resolve those issues. Those are issues which have to be resolved either through a mediated process or by litigation, and that is not this litigation. So those are issues which I agree with you would inevitably arise in the pursuit of an application for letters of administration, and the most friendly way of trying to resolve them is through a process of mediation. Other than that, then a trial court would have to be moved to take accounts, to order that accounts be taken, and to receive those accounts and to make certain decisions. But that is not something which we can do. We can certainly encourage the parties to adopt a process of mediation to resolve those problems. First of all, to identify the problems, to list them so that there is clarity on what is it we need to resolve, and see whether you can have a mediator process to have a little bit of give and take, and have a mediator assist you in resolving them. And if they can't be resolved, then I'm afraid that, you know, you would have to, someone would have to trigger another set of litigation. But
President, what we can say, however, is that the issues that have been litigated thus far, some of those have been settled, Mr. Hughes. For example, the ownership of who owns what properties that have come forward in this litigation. You know what I mean? So those are issues that are settled.
Sorry, Judge, may I just, perhaps not seeking to take issue, but point out that the Court of Appeal in its decision, the written decision, as opposed to the transcript, said that the deed of gift, the agreement of sale, and the lease,
those are the 2006 documents.
The 2006 documents were valid. Now, the logical conclusion of
they said the trial judge having set aside the various convincing documents, and this court having found in favor of this, but for different reasons.
No, not that's if I don't particularly want to litigate it, but
check paragraph 75 of the judgment, Mr. Hughes.
This was the judgment of the
Court of Appeal. Paragraph 75
and 72.
Right.
I can put 72 on the screen, but I could put.
Well, Your Honor, you see, therein lies some of the difficulties we faced. 72.
The judge having set aside various conveyancing documents, I think those are the 2006 documents, and this court having found in favor of this, but for different reasons. You see, the Court of Appeals said that the revocation should have been reconciled. So they came to the conclusion, Mr. Hughes, but by a different route. We agree with that, but it doesn't change, as we say, certainly in Trinidad, the price of cocoa, i.e., that the conveyancing documents, and by this they're speaking about, I believe, the 2006 documents that you particularized, was set aside, and we agree, albeit for different reasons, doesn't matter. So that's
res judicata. Nobody has anything against that.
So that's why I am saying, Mr. Hughes, that, and maybe it is that when we formalize our order, we will have to be careful about some of this, and maybe in some recitals. I don't know how we will do it, but there are certain issues that this litigation has laid to rest. I was just being illustrative to say one of the issues that has been laid to rest is these, what they call conveyancing documents, and i.e. the trial judge and Court of Appeal were ad idem on outcome, i.e. they should be set aside. That being the case, there are other accounting issues which you have identified, you know, but this is not an issue that should come up again. As the President said, it's res judicata. So it's not, you're not starting from scratch in the accounting process. You're starting with certain fundamental property issues having been determined. Yeah.
Guided, Your Honor. Thank you.
Mr. Hughes, who's in charge of the property right now?
The property is occupied by the respondent and has been occupied by the respondent prior to the loan being liquidated with Scotiabank. What had happened And this is just a chronology.
So
of
Robina
events.
has been in control of the property since then.
Indeed, Your Honor, but I think it's important that what had happened was her brother died, a brother who lived with her died, and she remigrated to Guyana. And when she remigrated, she started to manage the property, and then
That's
after
fine, Mr.
that,
Hughes. So the question is, she no longer being able to maintain any claim to ownership. Is it not the consequence that she must now give it up to the administrator? Control operation?
Well, Your Honor, my reaction to that instinctively is I'd rather be heard on that.
Well, then
because there are other. Well, Your Honor, and it comes down to the loan agreement and what was intended by the parties at the time the loan was executed. She was placed in position for the purposes, if it's a loan, of recovering the monies that had been outlaid. And it wasn't just the money for the repayment of the loan. There were several other loans that were made to the business, so to speak. So she was allowed to manage the property, and she was placed in possession of the property for that purpose. She salvaged the company. Sorry, it wasn't a company. Sorry, salvaged
you are
the
saying
business.
that she has a right to remain in control of the property, notwithstanding that she purported to continue in control on the basis of ownership, that ownership having been rendered completely untenable. She is entitled by virtue of the earlier agreement to remain in possession.
Well, Your Honor, the issue of ownership
what stops the estate from revoking her possession?
I never sought to assert that at all, Your Honor. I'm not saying that the estate is without legal authority. So I'm not for a second.
Well, it seems to me, just on principle, Mr. Hughes, that she must give up the possession to the estate. Well, it seems to me that the estate is able to say, give possession to me now.
Even except, Your Honor, there are, yes, sure, certainly in terms of the estate, the issue is what comprises the estate, because she has her own business that also has assets there, but this is perhaps not the forum. I have heard Your Honor's statement on that. And so we would just ask if that is the position that is being identified by the court, that some time be afforded for that to happen. It's not something that can happen overnight. So in the circumstances, again, that's another issue that is likely to arise as a consequence.
How much time would she need to give possession of the estate to Ramsaywar Basdeo?
I would imagine, Your Honor, a month, I suppose. There's equipment, logs, all sorts of things. It's not it, and there'll have to be an inventory before there's an argument over what is the inventory that is in the yard. It's not a small operation, so to speak.
Mr. Hughes, sorry.
If I may add, President, there may have to be an updated inventory. I do not know what Ramsaywar Basdeo will do. And in addition to that, I suppose Justice Barrow, my brother, is really looking at the issue from the point of view of when the grant of letters of administration have been issued.
So it seems to me, Counsel, that if we give you a month to for your client to hand over the properties belonging to the estate, that should satisfy your sense of the time needs. And remember, the order will be liberty to apply. So if you need an extension of time, then you apply for an extension of time. The other side will be able to object or consent or whatever. But it seems to me that some time frame needs to be put in place for Robina to hand over to Ramesh.
Your Honor, I appreciate and thank you for that. It's only that I'm trying to avoid future problems. So if she were to leave today, then and somebody says that this wasn't there, it's the orderly transition I'm trying to achieve.
But Mr. Hughes, I think what we're trying, and we're happy for your input is what would be reasonable for you and your. In other words, I think where we are, it seems, and this is good progress, as you've asked us to explore. Upon the grant of the letters, because we are, we're going to stay this, the letters be applied for by Ramesh. Okay, upon the grant of the letters, the property vests in the estate, correct? That's the law. So then thereafter, how long do you think your client would need to do the processing? Do the inventory? The inventory will have to be filed.
We've lost you, Yana. Hello?
Yeah, I'm not
somewhere
sure. Yeah. Go ahead, Justice Jamila.
Yeah, no, I was just exploring with Mr. Hughes, so that if his input is received, then we avoid unnecessary applications for liberty to apply.
No, Your Honor, that is precisely why I attempted to make the intervention early. Given the timeline that you have outlined, I think it is evident from now the starting of the commencement of the taking of the inventory and all the other contractual arrangements that exist will start. I'm assuming that the grant of letters of administration would probably take a fortnight, 3 weeks. I'm not sure how long my friend would take with that. And then I would ask after that maybe 6 weeks, 2 months, Your Honor.
Because we also have a holiday. We have a holiday period coming up, right? So we need to be practical in terms of real people's lives, and what's doable. So are you suggesting then 2 months would be?
I didn't factor in that issue. Your Honor, just 1 minute, because I just have to find out if they have logs coming down the river or anything like that that is likely to. How long would you need? Your Honor, given I've just conferred with the client, 2.5 months, Your Honor, only because it's the season, the notification to the staff, all of these have been issues before.
No. For my part, 2.5 months is actually not, I think, unreasonable to vacate the estate property, and given the nature of the enterprise, this is a sawmilling business, right? And anybody who understands what that is about, I have a little idea about it. It takes some doing. So I for myself, I don't know if the other, if Mr.
And Mr. Hughes, I fully agree with my brother. And for your purposes, it may be useful for your client to be advised that it will be the obligation of your client handing over property to make an inventory of what she is handing over.
Yes, absolutely. Your Honor, that was always our advice, that inventories and records should be very carefully maintained. So absolutely.
For her own benefit as well.
For her own benefit.
Yes.
And independently verified. Mr. Hughes, part of our experience as litigators is she may file the inventory and then they say, oh, that's not it, it's her word. But the way you avoid that is you get it can be independently verified. So somebody speak to the lawyer on the other side, your friend, and say, all right, we want to do this handover the inventory. Can we agree on third party A or B who will come and verify? And so that you don't have a dispute. Well, no, it was 1 log less and 2 logs more. You know what I mean? Because both parties have an independent.
Your Honor.
Yeah. So I don't know if that is some of the practical things you're talking about, but all of us have been experienced practitioners, and these are things that are known, and things like that. But I don't think it's our role to sit down with you and guide you through the practicality of it.
No, Your Honor. I appreciate this assistance. I was just indicating what the experience has been before and trying to avoid it with a multiplicity of applications to the court, when you really should just come back to report the handover and the progress. So 2.5 months after the grant.
Sorry, why? Why after the grant?
Well,
why not 2.5 months from now? The inventory process can take place starting now.
I wasn't suggesting that we wouldn't start. The inventory process will start now, Your Honor. I was just relying on what was said earlier. But I have no difficulty with Your Honor.
2.5 months starting now. If you need an extension of time for good reason, then apply.
Your Honor, there was no contest there. If that is the order, that is the order. No contest at all.
Okay.
Your Honors, may I just quickly kindly request if a time can be fixed for the taking of that inventory, because I anticipate that there will be a lot of problems resolving what are the assets of the estate. For example, there are forestry concessions that were in the name of Basdeo. No one knows if they are still in the names or they have been transferred. So I anticipate they will take some time to settle the list of inventory, what are the assets of the estate, and perhaps this court can assist the parties by fixing a timeline.
Mr. Narayan, let me interrupt you. The question as to agreeing what belongs to the estate and what is not, what ought to have been handed over and what ought not to have been, etc., is a separate matter. The starting point is for Robina to hand over that which she accepts must go to the estate. If the estate says, hold on, you have not accounted for these things, etc., then that is for the estate to pursue in the appropriate manner and forum. But it is not a question that before there can be the inventory done by Robina, before there can be the handing over, there has to be the disputation as to the accuracy and reliability of the inventory.
Very well, Your Honor. But
the purpose of the inventory is an accurate record of what she takes and what she leaves. And then the disputation, if any, will follow. But what you don't want, what you want to try and avoid, which we can easily avoid, is a disputation about what was taken and what was left, not what should have been. You know what I mean? So that's the accuracy that we after this point, when we suggested get a third party to simply to verify accuracy. That's all.
Okay, so far I think we're making excellent progress. So far, what we agreed is that Ramsaywar Basdeo will proceed with the application for the grant of letters of administration. Secondly, that let us say the end of January, on or before the 31st of January, Robina will, and I'm sorry to call you Robina, ma'am, but that's what we've been using all along. It's no disrespect to you. But you will.
Sorry, Mr. President, you were breaking up. Sorry, you were breaking up. We were hearing you, Mr. Cato. I'm sorry. Okay. 31st of January, I understand that's probably the vacation.
We're hearing you well, President.
Yeah, I'm hearing you well, President.
Mr. Hughes's end.
Yeah. Okay, so the orders that we'd make is one, that we would stay these proceedings. Two, we would order that Ramsaywar Basdeo proceed with haste to complete the application for letters of administration. Three, that Ms. Robina Basdeo will vacate the property of the estate that she is in possession of and will provide an inventory of what is on the estate of which she is currently in possession by the 31st of January, 2024. I believe by that time as well, she should provide an account of any claim or claims that she has against the estate.
President,
I'm sure that in there we will affirm the decision of the Court of Appeal as to the disposition of the property, although it is inherent in what you have said.
Yes. Justice Rajatli, was there something
Yes,
you
I
wanted
was
to
just
add?
ask you, President, if we were also going to make an order that was discussed today, that Robina Basdeo, or that there would be some sort of independent inventory of what was being handed over between the
that the
parties
inventory,
on the 31st. Yes.
that the inventory that is done be independently verifiable. Yes, be independently verified.
At the handover. Yes.
Yes. Is there anything else that we could do today, Mr. Hughes or Mr. Narayan?
None that I can think of immediately, Your Honors have achieved a great lot in bringing about a resolution of these issues between the parties.
President, can I add one thing, please? And this is just maybe from my own experience, and it may be that we don't want it, is for Mr. Hughes and Mr. Narayan to think about, is that in the, I'm saying this loosely, and we can refine it, in the handing over, that there be no waste. And by waste, I mean no damage done to the property. There's a term of art that I have, forgive me, excuse me now, when you have receiverships, but the language is basically that in the process of handing over, that the property, I think the word is waste, meaning that, the property is not, in landlord and tenant is, due wear and care only then, so that, the property is not wasted, it's not damaged and so on. Vandalized. And so that maybe we could turn it up, President, if they agree, and find the terminology. But I think it's a useful thing to put in if you all will agree to it, because since this is a public hearing and the parties are all present, it allows us to say to them and for them to hear us saying that in this process of handover, you can't, you have to do it in a way that is respectful of what you leave behind, etc., etc., etc. So I don't know if both of you think that that is something worth putting in the order and will subscribe to it and will support it. And whether, of course, my brother and sister judge would agree also. I'm just suggesting it.
I am fully supportive of such a provision in the orders, Your Honor.
I'm not opposed to it, Your Honor, but what I envisage is that we were going to hire the professional services of someone who will manage this process and independently verify the state of the equipment and whatever else is there, because I believe, certainly speaking for my client, we would want that protection of an independent arbiter at the time of handing over.
Sounds quite wise, Mr. Hughes.
Thank you, Your Honor. So that subsequent claims can be avoided.
So maybe then what we're talking about is just to put some language to it, and so we will know that we have at least discussed it, that at the time of handing over, when we're talking about the independent verification of inventory, we're also talking about the a verification of the state and condition of assets then. There are two things then. The inventory is a list of what is, right?
Yeah.
But where I think we are nuancing it is now to say, okay, in addition to lists and what's on the list and not on the list, as the case may be, also state and condition. Yeah. Is that what where we are in this? Yeah.
No, I wasn't seeking to interrupt you. Please forgive me.
No, I'm finished. I mean, we're discussing this in a collaborative way, right? This is not a act thing. We're all talking together, Mr. Hughes, about this.
Yes, I just want to. Sorry.
To that. Sorry, Mr. Hughes. I have no objection to that, Your Honor.
No. I was just going to say that there's equipment that has been there since Mr. Basdeo during his lifetime. Still remains on the property, and I'm sure whoever we hire, whichever accounting firm or professional firm, they will make a due note of it.
You see, Mr. Hughes, that's very important, because somebody may come after and say that this equipment was in good working condition and then you left it damaged, and then that raises a spin-off issue. That's why I think it's a good thing for both of you to do, to have it independently verified. Yeah, good.
So in the inventory,
that
Mr. Hughes, items will be described as derelict.
Yes. If they are
Yes,
such.
but yes, and I'm really not seeking to add to the complications, but they were anyway. It's just that there's equipment that clearly was no longer operable and functional since when Mr. Basdeo was alive. That is still there, and it will be accounted for. But when it's described as derelict, it may suggest. Anyway, we'll leave that for the time, Your Honor. We will have an independent professional company deal with those.
President, for my part, I would really like to pay a tribute to both counsel for their great helpfulness to the court. I have been really uplifted by this kind of cooperation, support, and assistance. Thanks.
And President, can I add to the parties? Because without the parties present,
I hope
we also would not have been able to achieve this.
And may I add, President, allow me please to say that I hope that this spirit continues.
Your Honors, before we close, there is one issue which I've been asked to raise. Two of the brothers have their residential homes in the compound of that sawmill, which, of course, they removed from after the constant fighting. Whilst they have no intention of disrupting in any way the business there, would they be permitted to re-enter their homes, which is in a separate part of the sawmill compound?
How long have they been? How long have they been out of possession? Why can't they wait until the? So why can't they wait until the end of January?
They can wait, Your Honor.
It's better that they wait, so that there is nothing that can arise in between. Let's have a clean 31st of January, on or before. The parties will agree, or council will agree on a date, a time, when there is an orderly handover. Let's not muddy the waters by having these two siblings go back in and then risk further disputes arising. I want to say this before we close, that, I am speaking now not to council, but to the parties, all of your siblings. And there are equities on each side of this issue, There are those siblings who justifiably would like to inherit what their father built and died and left for them. And there is a sibling who, from what I've read, did a lot to save this business, to invest in it at a time when things were bad, things were down, so that each side has a legitimate interest and claim, but at the end of the day, you have to look beyond your narrow interests and see what honors your parents, see where they are now, what they would like to see. And I am sure that, notwithstanding all the litigation, because I saw that there was some litigation even between the father and Ms. Basdeo, Robina. But at the end of the day, I am sure that everybody wants to see a spirit of peace, harmony, and I think that that is achievable. From all reports, this is a profitable business, and I'm sure that it could continue to make profits, and that each of the siblings will get a share, will have a share in those profits. So I think we've achieved quite a lot today. We will prepare a proper order. We'll have council have a look at it before we perfect it. It's not going to be a consent order if the parties don't want to place their consent on it, because we don't intend for this order to be held up by the unreasonable positions taken by one side or another. This matter is currently before us. We are not going to allow for it to be withdrawn. We are going to stay those proceedings, but we would certainly let you have a copy of the orders that we propose to make, which will be along the lines which I had recounted earlier. And after you've had a look at it, if you have any concerns, queries, then we'll give you an opportunity to indicate what those are. but at the end of the day, we will continue to, we will make the order that we think is appropriate in the circumstances. So I endorse Mr. Justice Barrow's commendations to council and to the parties as well. And we will try to get that draft to you sometime early in the course of next week so that we can get your comments on it before we finalize it. That's it for today.
Yes.
Your Honor,
On behalf of my clients, I wish to thank this honorable court very much for its patience in dealing with this matter, for its intuition in foreseeing likely problems and resolving these issues, and for taking the steps which I am sure will save the parties in council hearing maybe many years of future litigation, simply by the orders that have been discussed and adopted here today. And on behalf of my clients, I wish to thank this honorable court very much, Your Honor. Thank you.
Thank you.
May I please, Your Honor? I just would like to thank the court for its graciousness and its very gracious comments, and endorse what my learned friend has said. I thank you.
Thank you. Thank you very much. Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Madam Justice Rashnatley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. And thank you, Mr. Justice Jamala. Thank you, Council. And a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.
Okay.